1/7/2026, 1/28/2026, and 2/4/2026. You failed to participate in your stipulated sex offender program through CTPSB as instructed. Due to your failure to attend the program, you were placed on verbal warning on 3/11/2026. On 3/11/2026, you were given a written warning due to sending ongoing text messages to your group therapist for purposes unrelated to treatment.
Okay, so let's get into this one right here. Today we got not one, not two, but 3 different parole revocation hearings. And all 3 of these cases got something in common. They were already given second chances and somehow ended up right back in the system. Now, if you've been here before or you just got people in the system, you already know revocation hearings hit different. This is not your first chance. This is after you already was let out and then you violated. So let's break this down one by one. The first one, we got an older dude, OG status. He comes in talking about how he completed 250 classes, only missed 3 because of medical reasons. Now, on paper, that sounds good. That's like what the board want to hear, but this is where it goes left. He got kicked out of his treatment program, unsuccessfully discharged. Why? Because he was sending inappropriate messages to his therapist instructor, the one that runs the classes. Picture that. You're in a sex offender class. You're sending your teacher inappropriate messages. And I'm not talking about 1 or 2 messages. We're talking about sending stuff like at all hours of the night, making therapists feel uncomfortable. And his excuse was what? He trying to say he was sending reels to her because the reels were related to the topic they were discussing during group. Topics related to class, huh? Come on now. Let's keep it real. That don't even sound right. That sounds like you was trying to run game and got curved.
Fine. Good morning, Mr. Newkerk. How are you?
You better?
Can you hear me?
Yes, I can. Can you hear me?
No. Mr. Newkerk, can you hear me?
Yes.
Maybe not.
Yes, can you hear me?
I can't hear you either.
They can't hear you?
Yeah.
Mr.
Mr. Tricello, I'll be right
Our
there.
media tech will figure this out.
Mr. Newkirk, I can hear you, so I'm just going to go over to the opposite room and check her audio.
Kristen, any thoughts?
They say they could hear you.
Can you hear me? Can you hear me?
They might have you muted for now. I don't know. But they were hearing me fine, so it doesn't look like we're muted. See on the top left.
There we go. All right, we can hear you now. Can you hear us okay?
Yes.
Perfect. And you can just fix the camera. Got it. All right, we're going to get started, okay, Mr. Newkirk?
Sure.
Okay, so good morning. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Omar Newkerk, inmate number 263816. Today is Monday, May 4th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Omar Newkerk, 263816.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning. Peter Matthews with the Public Defender's Office for Mr. Newkirk.
Thank you. So this is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Newkirk, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. After the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
All right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of problem sexual behavior treatment, the charging officer reported that on 12/12/2023 and 4/23/2025, you were issued verbal warnings due to non-compliance of the program rules. 1/7/2026, 1/28/2026, and 2/4/2026, you failed to participate in your stipulated sex offender program through CTPSB as instructed. Due to your failure to attend the program, you were placed on verbal warning on 3/11/2026. On 3/11/2026, you were given a written warning due to sending ongoing text messages to your group therapist for purposes unrelated to treatment, ongoing behaviors that violated the program's treatment agreement, and excessive absences. From 3/11/2026 to 4/13/2026, you continued these behaviors, including inappropriate text messages and failing to complete your assignment from your verbal warning. Subsequently, you were unsuccessfully discharged due to refusing to follow the course of treatment. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the Connecticut Department of Correction Remand to Actual Custody Order. Exhibit B, the State of Connecticut Board of Pardons and Parole's Conditions of Parole. Exhibit C, the Notice of Parole Violation. Exhibit D, the Parole Violation Report. Exhibit E, the Connection Unsuccessful Discharge Letter. Exhibit F, the Offender Misconduct Report. Exhibit G, the video/images. And Exhibit H, the Connection Written Warning Letter. Counsel, to confirm, you and your client did receive the Notice of Parole Violation, the Parole Violation Report, and all the other documents identified for today.
Yes, I did.
You're able to review those documents?
I was.
Perfect. I did not receive anything from the defense at this time. Do you need time to submit any documents?
No, I don't.
And we have no witnesses at this for today's hearing. So, counsel, it is now your opportunity to respond, make a short statement, and testify with respect to probable cause and the severity of the allegations.
I'd just like to start by asking Mr. Newkerk a few questions.
Sure.
Mr. Newkerk, why did you miss those 3 classes in January and February of 2026?
I was assaulted at my job where I sustained 2 broken ribs, and I was recovering from that. I had then in turn gotten sick because of my injuries. I came down with a severe cold and almost got a lung infection. That's why, pretty much why I wasn't, that was the reason for my absenteeism.
Thank you. And did you attempt to inform the Connection program about your medical issues?
Yes, not only did I attempt to inform them, but I also informed Lugo, of which she already knew of my my assault at my job, and pretty much they knew everything that was happening to me. They knew what was going on from the very beginning. I always kept them in the loop, and pretty much that was it. They knew what was going on.
Okay. Approximately how many Connection classes do you think you've attended in total while you've been on parole?
About 250.
250. Okay.
Yes.
Thank you. Now, with regard to the work cell phone, did Ms. Boswick give you that work cell phone number?
Yes.
When did she give you that number?
When she came into the class as a new clinician along with Elba.
Okay. So those reels that were sent to Ms. Boswick, what were they pertaining to?
They were pertaining to the class in relation to relationships. They were in a violent manner, when I was brought into a meeting with Officer Lugo, her supervisor, Ms. Boswick, as well as Alba and her supervisor, I tried to show them the videos which came from Facebook and from YouTube about relation.
So they were related to the material you were discussing in the class, is that correct?
Yes,
All right, and after your meeting on March 11th, when you received a written warning, you didn't send Ms. Boswick any additional reels after that date, is that correct?
no, I did not.
Okay. While you attended class, did you ever yell or use offensive language?
No, I didn't.
All right. Did you ever threaten anyone in class or make personal attacks against anyone in class?
Never.
All right, thank you. So the sole charge here, it pertains to Mr. Newkerk's compliance with the connection program. He missed 3 classes in the beginning of the year due to some medical issues he was dealing with. He indicates that his parole officer was aware of those medical issues. Since his last release from incarceration in February 2023, which is over 3 years to the date of remand, he has been continually engaged with this connection program. So it doesn't appear that he's being flippant with regard to his attendance by missing these 3 classes due to medical issues over a 3-year period. The PBR does mention 2 earlier dates, but it was unclear to me if those are both missed classes or lack of engagement on those 2 dates. But generally, over a 3-year period, it appears his attendance has been pretty good with this connection program. With regard to the reels that were emailed to Ms. Boswick's work cell phone number, first of all, he was provided with this cell phone number. It is not as though he was contacting her on her personal cell. The fact that these reels were sent late at night, there's a lot made of that in the PBR. But presumably the reason you have a work cell phone is that you're not working and you're not available, you're not getting messages from clients on your cell phone. I don't think the fact that these were sent to a work cell phone late at night is evidence that he was harassing her or being disruptive. I would assume her work cell phone is off when she doesn't want to receive messages from work. He was told to stop sending the reels in the March 11th meeting, and he did stop after that date. He didn't contact her again with regard to any reels or any messages to that number at all. The reels themselves, which Mr. Newkerk felt they were relevant to discussions they were having in class with regard to the subject matter. There's no evidence presented that any of them were inappropriate in nature in any manner. Exhibit E, the discharge summary, says he's being unsuccessfully discharged due to refusing rules. It says, despite warnings, he continued to send inappropriate and threatening messages to staff and the officers. None of the messages appear to be threatening in nature. The message sent to his PO in April does use profanity, but it does not appear that he threatens anyone in that message. In addition, I don't see how sending a message to his PO would constitute a violation of the parole condition that he comply with sex offender treatment. None of the sex offender treatment rules were included as an exhibit here, so it's unclear if there's a specific condition of the treatment that's being violated by Mr. Newkerk sending a message to his parole officer. The summary continues that Mr. Newkerk continued inappropriate, aggressive behavior in group settings and did not complete the assignments as requested. So I feel this is fairly vague. I get the impression that the staff didn't appreciate the comments that Mr. Newkerk was making in class and the amount of time he spent voicing his opinions, but I really don't see how this is sufficient to get him discharged from the class. It doesn't appear that any specific example of an inappropriate comment or behavior has been presented here. I don't feel that the evidence that has been presented shows that he violated the condition, complied with the problem sexual offender treatment. He was complying, he was going to the classes, he was speaking in class. He stopped sending the messages and the reels to Ms. Bogwitz after he was told to stop doing that. He missed 3 classes out of hundreds that he attended due to some medical issues he was dealing with. So if there is a finding here that there is probable cause that he violated this condition, I would argue that the violation is not serious enough to warrant revocation. I disagree with the conclusions noted in the PBR. I don't think it's obvious that he presents an imminent and inevitable risk to the community. He's been under supervision for the past 3 years, and the sole charge here is some issues he was having with the sex offender treatment classes. There may have been some more serious violations in the past, but that's not what he's here for today. There's no allegation he threatened anyone or engaged in any sort of criminal conduct. All of the misconducts noted in the PBR, other than that written warning from March 11th, are from 2023 and 2024. So they're years old. And I think that provides additional evidence that he's been complying over the past several years. I think he may have been a difficult client in the class and who spoke a lot, and he made comments that the instructors disagreed with. But I don't think there's evidence he was so disruptive as to warrant revoking his parole. He was attending, he can continue to attend going forward. The discharge letter says he may be re-referred if he's released to the community. Thank you.
Thank you, counsel. I'm just going to take a moment and I'll announce my findings. So on charge number 1, Mr. Newkerk, as your counsel stated, and I am aware of it as well, there were no treatment agreements attached to your file from Parole and Community Services. Therefore, I am not aware whether or not you were given those agreements and the rules and conduct that you are to abide by. So with that, I am making a no finding because I do not have the evidence to show that you were given those agreements, unfortunately or fortunately, however you look at it. So with that, I am going to reinstate your parole. Say I have to make a finding and no finding of probable cause based on that. I am going to reinstate your parole effective today, Mr. Newkerk. Just so you're aware, I'm not saying that the behavior did not occur, okay? I just don't know if you were given the information that you must abide by because it was not included. So just be mindful of that when you leave today, okay? All right, any questions at this time?
No, ma'am.
Okay, so this does conclude the preliminary hearing for Omar Newkerk, inmate number 263-861. All right, again, Mr. Newkerk, I just want to make that clear. I'm not saying that behavior didn't occur, but I don't know if you did ever sign a treatment agreement or were made of the rules that they're asking you to follow, okay?
Yes.
All right, so I'm going to do the paperwork now. The facilities records office will be notified as well as your supervising officer, and they'll get you out today, okay?
Okay.
All right, this concludes the preliminary hearing for Omar Newkerk, inmate number 263-816. Thank you, Mr. Newkerk. Thank you, counsel.
Thank you, sir. Thank you, counsel.
Think about it. You got to do this taking sex offender classes, sending you so-called content related to the topics at all types of hours. Sounds spooky, huh? Now, the crazy thing is he was granted parole again. And the reason why is not just because everything he did was right, but because the people in the program messed up the paperwork. You see that properly didn't document the rules, they didn't document him signing off on them, they didn't include any of this in his files, right? So therefore, he can't break rules that were never given to him. For those who don't know, I'm a drug and alcohol counselor at a treatment facility, detox and CSS, right? So the first thing they always say in the field is, if you didn't document the situation, it never happened. I don't care if you want to tell me this is what happened. If it's not documented, it never happened. And this is where we got to get better at, because this could be saving somebody from getting touched, from somebody getting violated, somebody dying, because he was just let back out. So basically, they couldn't prove he fully acknowledged to the rules. You got somebody going back to the community, not because they earned it right away, but because their paperwork was messed up. And these type of situations happen all the time. Now let's get into the second offender, right? Also a sex offender, but he didn't violate for new sex charges. He got violated for DUI, driving under the influence type stuff. And that right there should tell you something. A lot of times, it's not even original charges that bring people back. It's the behavior that was never changed. So now it sounds like he's sitting in Carl Robinson CI. And for those who don't know, you already know what it is. That's a level 3 facility, open dorms. I've been there before. Let me paint the picture real quick. You got two sides. It's side A and a side B. Main control center with COs watching. It's about 4 COs inside. You got bunks lined up, lockers next to each other, all types of movement everywhere. Showers on one side, day room and TV on the other side. This ain't no cell blocks. This is open dorm type of living. And with those type of charges, if you're not disciplined, if your mind ain't right, you're gonna struggle there. So now he's back in the environment, all because he couldn't stay sober.
You can just have a seat, and when he comes out, you can go in.
So, Kristen, come on in. I see +1 participant. We can see everybody. I just don't see the +1. That makes sense.
Yep, so if we have DeVilder,
Okay, because I can't see that she's here. I just see it says +1.
yep, I just don't see that her camera's turned on.
If that would make a difference. Okay. She's not on for this case, but I was just wondering if, I just wanted to let you know, like, I can't see who the other participant is, and besides the 4 that are on the screen.
Yep, just because only so many videos fit on your screen.
Got it.
But I can see that DeVilder has joined the hearing.
Okay, all right, thank you. All right, so we are going to start with Mr. Kohls. Just want to put on the record, counsel, his officer is not in the office today, so she will not be attending. Officer Bob was supposed to attend, okay. So good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning John Kohls, inmate number 326440. Today is Monday, May 4th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Carl Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
John Michael Kohls Jr., 326440.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Kohls.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better weight of your evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Kohls, can you please raise your right hand? You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Perfect. So I'm going to go over the procedure for today's hearing. So first I'm going to read your rights. Then we're going to review the parole violation charge that the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
All right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We will now review the charge that the state your parole officer is bringing against you and the information underlying that charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that Manchester Police Department obtained a warrant for your arrest, charging you with evading responsibility, Connecticut General Statute 14-224B3, and failure to obey stop sign, Connecticut General Statute 14-301C. On 2/7/2026 at approximately 11:05 p.m., Manchester Police were dispatched to report of evading a motor vehicle accident. The victim reported his vehicle was struck by a pickup truck that failed to stop after impact and fled the scene. During the investigation, it was determined that you were the operator of the evading vehicle. Police made contact with you, and at which time you admitted to having hit the other vehicle and fled the scene. Subsequently, on 3/4/2026, you were remanded into custody and served with a warrant held by Manchester Police. Your next court date is 4/2/2026 under docket number ending in 574S. The state has filed the following exhibits that were marked for identification purposes as Exhibit A, the remand to custody order, Exhibit B, the notice of parole violation, Exhibit C, the parole violation report, Exhibit D, the parole conditions, Exhibit E, the Manchester PD arrest warrant number 2600004867, Exhibit F, the CT judicial case detail, and Exhibit G, the parole violation report 2023 and revocation summary. In addition, they did file an addendum to the parole violation report on April 6, 2026 that states that on April 2nd, 2026, Kohl appeared under docket ending in 574S and was charged with evading responsibility and failure to obey stop signs. The case was disposed of on that date and both charges under that docket were nollied. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
We did.
Perfect. I did receive an exhibit from the defense and have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
I do not.
You have no witnesses. So at this time is the defense's opportunity to present evidence and speak to any of the evidence submitted. So, counsel?
Thank you. So the criminal event arrest for the evading responsibility, that was the sole basis for this violation. And that charge was nollied in court on April 2nd, as indicated in the addendum. At the time the nollie was entered, the prosecutor, he did state on the record that the vehicle involved in this incident was fully insured at the time of the accident. The police report does confirm there were no physical injuries during the incident and that the complainant refused any medical attention. So other than that, he was in complete compliance with his conditions of release for an extended period of time. If there is a finding, I would like to hear further with regard to the sanction. Thank you.
Thank you, counsel. Take a quick comment. So on charge number 1, Mr. Kohl, I have identified it as separate parts, and I'm going to make a partial finding. So although the court did nollie the charge, it does not negate that the behavior occurred. So I'm going to make a finding for the evading responsibility based on the evidence presented in State's Exhibits C, D, and E. I'm going to make a no finding on the failure to obey a stop sign, as that's an infraction. It's not considered a crime. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, counsel?
Thank you. Mr. Kohl, he's 42 years old. He was born and raised here in Connecticut with his family. He does have a good relationship with his family, including his father, his fiance, and his children. Mr. Kohl's father, he's 73 years old, and he himself is suffering from a lot of medical issues. And Mr. Kohl does help him with his care and taking him to his various doctor's appointments. Prior to his remand, Mr. Kohl was residing with his fiance, and his father was living with him as well. So when he's released, he's hoping to go back to live with his fiance and his father. They both really depend on him, and he was doing very well there for a period of time. I know when he was initially released to supervision, he completed a halfway house program successfully. He then transitioned to a sober bed, and after that, he transferred to the sponsorship of his fiance, where he was doing very well. Mr. Kohl, he does have his CDL license, and prior to the remand, he was working for a landscaping company where he was also a triaxle driver, as well as completing some landscaping work. He'd been doing that for about 6 months. He does have a very good employment history in the landscaping industry. He's a hard worker, and he's confident he will be able to return to his position when he is released from incarceration. He has complied with all the treatment recommendations that were made by parole without any issues. He completed the sex offender treatment program in its entirety. When he's released, he would like to engage in some group mental health counseling going forward. He does feel that could be beneficial to him, and it's something he's intending on taking up. He's been under supervision since his last release from incarceration in February of 2024. So at the time of the remand, the period of supervision was over 2 years. The PBR does indicate that Mr. Kohl was doing very well and complying with his parole officer and the conditions. The PO notes one misconduct right after he was initially released back in March of 2024. But since then, there have been no misconducts, and he's complied with all his treatment and conditions. Mr. Kohl does want the board to be aware he has undergone some medical issues since his remand. He did spend some time in the hospital due to kidney issues, and the doctors there did indicate that some further testing and treatment will be necessary. He is anxious to try to make these appointments with doctors and address his medical concerns when he's released. He hasn't had a lot of success addressing them, since his return from the hospital while he's been incarcerated. His parole officer does not make a specific recommendation as to the sanction in the PBR. I would recommend that Mr. Kohl be released at the next available date. By all accounts, this was a minor incident. The prosecutors, after analyzing all the facts and circumstances, did elect not to prosecute the charge, and they did note the vehicle was properly insured at the time of the incident. The warrant indicates there are no injuries. It also confirms that Mr. Kohl voluntarily reported to the police station later that day with all the proper paperwork and documentation. He's apologetic for what happened. He did indicate he was on his way to work and he panicked, but immediately when his shift was done, he went to the police department to let them know about what happened and provide them anything they needed. I would note that, as I indicated, the warrant says he was very cooperative. There's no evidence to suggest he may have been under the influence at the time of the incident. I think he made an isolated mistake here, but otherwise he was doing very well on his parole supervision. I think he was benefiting from the counseling, and he's going to continue to cooperate with parole going forward as he has been doing for the past 2 years. Mr. Kohl, is there anything that you'd like to add at this time?
No.
Thank you.
Thank you.
Now, the third offender, this one right here, this one might be more concerning because this dude was not even fully home yet. He was in a halfway house, which means you're already on your way out. You right there, and he still screwed up. Multiple dirty urines, weed, alcohol, skipping treatment, sounding out like he was going to programs, but instead he's going to the weed dispensary. Got caught with weed, staff walks in, he's got half a joint in his hands, he had to give it up. Got caught with nips, just reckless. This is the type of situation where you gotta be honest. This ain't just bad decisions. This is a serious substance use problem. Because if you can't follow the rules in a halfway house where you're being monitored, structured, and supported, then what you think is gonna happen when you're fully on your own? And it sounds like every time he gets high, he tends to reoffend. So you know what that means, right?
2025, you were found to be in possession of paraphernalia for smoking marijuana, which is prohibited per your halfway house treatment agreement. On 11/6/2025, you returned from a pass and were found to be in possession of both marijuana and a makeshift pipe. The behavior violated in your halfway house treatment agreement as you are not to possess marijuana in a halfway house. On 11/24/2025, you are in possession of a nip bottle that has been made into a pipe for smoking that smelled like marijuana. At no time are you to possess contraband for smoking substances in a halfway house. On 12/5/2025, a half-inch marijuana joint was located in your locker during a room search. At no time are you to be in possession of marijuana in a halfway house, as this violates your halfway house agreement. On 12/18/2025, you were found to be smoking a marijuana joint in the bathroom of Open Hearth Halfway House, and you gave the joint to staff. At no time are you to consume marijuana while in a halfway house. On 1/9/2026, while conducting a search of the area of your direct control, halfway house staff located an empty nip bottle of alcohol and a marijuana pen. At no time are you to be in possession or consume any alcohol or marijuana while in a halfway house. On 1/15/2026, you are found to be smoking marijuana in the halfway house. At no time are you to consume marijuana while in a halfway house. On 1/16/2026, you are found to be smoking marijuana in the halfway house. At no time are you to consume marijuana in a halfway house. On 2/2/2026, you are found to be smoking marijuana in the halfway house. At no time are you to consume marijuana in a halfway house. Also on 2/2/26, you were issued a pass to the American Job Center. Instead of going directly to the only location on the pass, you went to Park Street. Per your halfway house treatment agreement, you are to report directly to and from designated locations on your pass. This is a misuse of the pass system and a violation of your halfway house agreement. On 2/4/2026, you were smoking marijuana in the bathroom and in your bedroom at the halfway house. Consuming marijuana in the halfway house is a violation of your halfway house agreement. On 2/26/2026, you were issued a pass to CRT for a medication management appointment. Prior to that appointment, you called and canceled due to transportation issues. Yet you left the halfway house under the guise of going to treatment. Per your halfway house treatment agreement, you are to report directly to and from designated locations on your pass. This is a misuse of the pass system and a violation of your halfway house agreement. On 2/26/2026, Cheney House directed you to render a urine and you refused to provide a sample. This violates your halfway house agreement. On 2/28/2026, at approximately 9 a.m., you were found to be urinating in a shared open space within the halfway house. On all the aforementioned dates, you violated your halfway house agreement. Charge number 3, mental health treatment. On 8/18/2025, you failed to attend a medication evaluation appointment with psychiatry at CRT. On 10/15/2025, you failed to attend a psychiatric evaluation at CRT. On 10/21/2025, you failed to attend an individual psychotherapy session at CRT. On 2/26/2026, you failed to attend a medication management appointment at CRT. You contacted them to say that you were unable to attend due to transportation issues, yet you left the halfway house on a treatment pass to CRT and instead went to a marijuana dispensary. On each of the aforementioned dates, you failed to participate in mental health treatment, which violates your mental health treatment stipulation.
Thank you. And you also have provided evidence in support of the case. Can you please identify the evidence for us?
Yes. A, PCS signed conditions. B, parole violation notice. C, parole violation report. D, remand to actual custody order. E, halfway house agreements. F, GPS agreement. G, CTPSB treatment agreement and discharge letter. H, emails, misconducts, disciplinary reports, incident reports, photos, attendee GPS monitoring evidence, etc. And then I, revocation hearing summaries dated 7/6/2024 and 12/23/2024.
Thank you. Counsel, to confirm you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes.
And I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole and statement. Counsel, do you need time to submit any other documents?
No.
And we do not have any witnesses. So at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. So Officer DeBow, are there any comments right now towards the charges?
Yeah, just in regard to the charges, I just want to reiterate, and as you can see from the previous violation that Mr. Campbell has had, these behaviors, the failure to abide by halfway house treatment or the halfway house agreement or mental health and medication management. I would just like to say these are continued things that Mr. Campbell fails to do. So just wanted to put that on record. Thank you.
Would you put on hold? Both of them?
Yes.
Okay, I'm sorry, taking some notes.
Counsel, it's now your opportunity.
Yes, just briefly, the charges that on the PVR by Officer DeWilder. Can I just make one correction, P.O. DeWilder? I didn't want to interrupt you while you were reading.
It's DeWilder. Thank you.
On the GPS, I believe you meant to say it's 1/16/26, but I believe you put on the record it's 1/26/25. Is that? I just want to make sure I have the right document. That's when he signed his condition. It's 1/16/26.
I'm just looking for the actual agreement. Yes.
Okay, I just want to make sure. I'm pretty sure it was 2025, but 2026 is what I have. Thank you. Mr. Campbell, just briefly, I don't have many questions regarding the first part. The issue, Mr. Campbell, with your unit on February 26th, where you failed to charge GPS as required, the shutdown from 11:38 p.m. to approximately 2:22 p.m. Do you recall what happened?
I believe I just fell asleep and then in my sleep it knocked off.
Okay. The charge number 3, Mr. Campbell, under mental health treatment for August 18th of 2025. Do you recall what occurred? Did you go to walk-in or did you go to the hospital on that particular day?
I do remember going to a hospital, but I'm not, the dates, they're blurry because a lot of times, as I explained to, Bill, the elders, like, because of, you know, a record of mental health, not only just the mental health, but without that factor, just being human, sometimes I forget, or even with the GPS situation, like, because I didn't have, you know, a phone with me to be like, all right, which bus am I supposed to get on? I made a mistake and was looking to get on one bus, but basically got my directions, you know, twisted. I think I actually did that a second time in getting misdirect, like, you know, having my directions incorrect and intending to go to mental health, you know, locations and just.
All right, do you recall specifically if on August 18th of 2025, you either went to a walk-in or to a hospital? If you recall, if you don't.
I don't remember the date exactly, but I do remember going to a hospital, a walk-in, and
Okay.
I do have the discharge papers. The date exactly, I can't say for sure that the date that you're stating is correct, but from my recollection, it was more than one time that I did go to the hospital and I did get discharge paperwork. That can be verified.
Okay, and did you discuss either with P.O. the filer or anyone at the halfway house, your visit with your paperwork?
Yes, I did.
Okay,
And I brought back.
to the halfway house?
Yes.
I don't have any other questions regarding the first part of the hearing.
Anything additional from either side before I announce my findings?
No, ma'am.
Mr. Campbell, still on charge number 1, I'm going to find that you violated the condition of GPS based on the evidence presented in States Exhibits A, C, F, and N. Charge number 2, I'm also finding you violated the condition of halfway house placement based on the evidence presented in States Exhibits A, C, E, J, K, L, and H. On charge number 3, I'm finding you violated the condition of mental health treatment based on the evidence presented in States Exhibits A, C, and H. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, Officer Diviler, any statements at this time?
Yeah, I'd just like to make mention that this is Mr. Campbell's 4th violation while in special parole supervision. Campbell self-reports paranoia and other mental health symptoms, but has failed to comply with a stipulation of mental health and medication compliance during any time in the community during supervision. I have consistently attempted to get him into compliance with this, and he was afforded 9 months in the community to establish this mental health treatment and medication compliance. Yet, as you can see, Campbell does not follow through and has even made the decision not to attend his most recent appointment, but to go to a marijuana dispensary instead of a crucial appointment with CRT. Given his history of mental health symptoms, his self-medication with marijuana and alcohol is concerning, as these substances are known to exacerbate the symptoms he describes, which is a safety concern. Both the failure to comply with mental health and the use of substances greatly increases his risk to sexually reoffend, which is a significant safety concern. This is why he was negatively discharged from sex offender treatment. Campbell has no viable sponsor in the community, and halfway house placement is his only option. Yet he continues to deviate from passes, possess contraband, and is consuming marijuana and alcohol within these facilities. Based on his continued in escalating use of substances, continued misconducts, mirroring previous non-compliant behaviors, demonstrated inability to abide by halfway house rules, and failure to participate in treatment, parole is requesting a minimum of a 1-year sanction. Thank you.
Thank you. And counsel?
Yes, on behalf of Mr. Campbell, Mr. Campbell, he's 44 years old. He was born in Los Angeles, California, and then moved to Manchester. He was obviously at the halfway house up until his time of remand. He did report to us. He did graduate from Manchester High School. While he was on supervision, he did indicate to us he did utilize the American Job Center in Hartford for employment assistance, and he has applied for disability for medical purposes. He did indicate to us while on previous supervision, he was working full-time as a selector at AD USA Distribution in Manchester for a couple of months, and then he was going to CPA, the Community Partners in Action Reentry Welcome Center in Hartford for employment assistance, where he did indicate to us he did submit some applications there. He has completed anger management in the past at Wheeler Clinic, is what he reported to us. Also did report to us, looks like in September of 2024, he did participate in outpatient services, the anger management once a week, and 2 individual therapy sessions at CRT in Hartford. His primary care services established in Hartford, and he does work with a dermatologist for some skin issues. As indicated by his parole, he does not have a sponsor. He is amenable to halfway house either in New Haven or in Hartford. Does want to enroll in trade school to either study welding or CNC machining. He did apply for medical disability and is amenable to part-time work because of his medical conditions. As indicated, he does not have, unfortunately, a viable sponsor, so he is looking for halfway house placement. And I know he was out for approximately 9 to 10 months. These are technical, there are no new criminal arrests in this particular violation. Thank you.
Anything additional from either side before I take a moment?
No.
So I have listened to the testimony today, Mr. Campbell. I've also reviewed all the evidence submitted. Based that, I do want to just validate. I've heard Officer DeViler's testimony about the continued work with you in the community. And you were only out for about 9 months in between your release and when you were remanded. And in that time, everything she put on the record, as well as the 16 misconducts, the behavior is just continuing. So it's definitely concerning. So with that, I am going to recommend your parole be revoked and that you serve an approximate 1-year period of confinement as a sanction. That's with a re-parole date of March 4th, 2027. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for anger management, no contact with victim NL and AL, a general no contact with EQ, mental health treatment, no contact with minors, problem sexual behavior treatment, and halfway house placement. So what happens next, Mr. Campbell, is my recommendation is going to go to the board on May 14th. On that date, the board can do 3 things. They can lessen that recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a period of confinement longer than what I've recommended, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
I would like to make the statement that it can be verified by phone records, not just by the staff at CRT, that many of those dates that said that I missed quote unquote mental health treatments, that the mental health examiners or prescribers were either called out or did not show. And the only way that I would be able to leave the halfway house was with it, because I can't control the scheduling of when I'm able to get a pass to establishments such as CRT. So if it's not on my schedule to leave, then I probably won't be, I will not be allowed to leave the halfway house. So if necessary, we could go back in the phone records and, verify the dates where if I was supposed to have, or supposedly call myself and, make a change, the only way that I'd be able to leave the halfway house if that change was also reflected in my schedule done by my counselor. And multiple times I've spoke with counselors about issues that I've had with because in areas of my control, like there are three different storage areas that usually that you're afforded, and if I'm only allowed one lot to secure it, all the other areas that that I'm supposed to be able to or I'm supposed to be responsible for, if I have three places that should be locked and under my control, and I'm only able to secure one, that leaves me susceptible to other people accessing, either taking or putting things into my area that I may not be aware of if I'm out on a path, such as sexual behavior or mental health treatment or cognitive behavior treatment or anger management treatment. So like whatever decision is bestowed upon me, I would beseech the court to please, when I'm in a situation such as that, allow me to have the ability to secure my areas so that I'm able to be sure, as best of my knowledge, that they are not being tampered with or altered outside of my presence.
Thank you, Mr.
And your statements, I need to put those comments on the record. As she indicated, this is gonna go to the board on May 14th. They're gonna get a transcript of a written report, and then you'll have a final decision about 7 to 10 days after. I'll get a written copy, and you will, Mr. Campbell, the final outcome. If there's an issue with that recommendation, with the sanction, anything changes, I'll set up a call with you and explain everything to you. But you and I will get something in writing, okay?
Yes, sir.
All right, good luck to you.
Good luck to you, Mr. Campbell. This concludes the revocation hearing for Paul Campbell, inmate number 422-413. Thank you, Officer DeVato. Thank you, Attorney.
Thank you, everyone. Have a great day.
Good luck to you,
Good day.
Mr. Campbell.
Thank you.
A Mega Drip exclusive.